Good morning. I'm Howard Nations. Most of you have been on with me before, and the this one. Let me mention before we get started that if you need closed caption, if you look down along the bottom of your screen, uh, you'll see show captions and with a CC. So if you need closed captions, you can do that. Also, you're going to have the opportunity to ask questions through the chat line. So if you look along the bottom of your screen, you see chat, and you press that, and you can write your questions in. I'm going to take questions. I'm going to leave a considerable amount of time at the end of this for your questions. So let me get started. There's been a lot happening since we had our last conference, and some of it good, some of it bad. Uh, we are now in a situation where uh, we are preparing for trial, uh, and we feel like that this is actually going to be the one. It keeps getting postponed and postponed and postponed. But let me tell you what's going on first. Let's start with Navy JAG, where you file the administrative claim. In order to qualify to stop the running of the statute of limitations, we have to take your case to the Navy JAG administrative claims section, and we have to file a claim there. That claim stops the running of the statute of limitations on your case. Now, um, we're very up to date on our filing of claims. All of your claims are on file except for those who came in recently, and so we don't have a problem with the claims. There's a huge problem at Navy JAG right now. They are so overwhelmed. They've been overwhelmed since day one, and it's causing a massive problem for us. Right now, about 2 years ago, in June 2 years ago, I went to Navy JAG to the head of the Administrative Claims Department, and I said, what are you doing and what can we do to help you to prepare for handling the administrative claims that you're going to be receiving? And he said, what are you talking about? And I said, well, you're about to get about 250,000 administrative claims. He said, where from? And I said, well, we're about to pass the Camp Lejeune Justice Act. He said, no, nobody's paying any attention to that. They've been trying to pass that thing for years. And I said, well, I'm here to tell you, we have the votes. We're passing the bill this time. So you need to be ready to handle about 250,000 claims. Well, they did nothing, and they didn't believe me. They did nothing. So come August 10th, they started getting claims flooding in. They were flooded. We filed our claims on February 10th. We had the ones we had, August 10th. We filed our claims first, and at midnight, as a matter of fact. And they've been behind ever since. They are now in the situation where, unbelievably, they are so far behind that they don't know themselves. They can't tell you themselves how to solve problems. And it's getting to be a real threat because the statute of limitations for filing claims is August 10th. As of today, the Navy has 232,892 claims on file. That doesn't mean they've processed them, but they have that many that they acknowledge as being on file. And we still have a little over 2 months to file claims. So the problem with it is they set up a new portal system, and we even had to discuss it with the court in the last session this week about how terrible the claim system, the processing system is not working. And so it's just a complete mess. In addition, I think in the next 60 days, I think there'll be at least 30,000 more cases filed, 25 to 30,000 more cases. So they'll end up at around the 250 mark. Now, the other thing about Navy JAG is that they are the ones that are administering the EO program. So let's talk about that aspect of settlement. I had a whole program with you on the EO claims. The EO claims are the ones where the Navy and the Department of Justice got together and set up a program called the elective option, where they would choose people who are eligible. And from those people they choose, they would send a letter to their lawyer and to them saying you've been selected for the elective option opportunity to settle your case. Well, as I told everybody at the time it happened, that was a complete scam by the Department of Navy trying to buy cases, settle cases for pennies on the dollar. So just to bring you up to date on where that is right now, they have settled, they've been trying to settle cases. They set that system up some time ago to try to settle cases through this process. Now, I've seen lawyers advertising on TV that if you are whatever, you can, if you're pending in Navy JAG, you have the opportunity to settle your cases. And if you sign up with us, we'll submit your case for settlement. Well, like most of the advertising you see out there, that's wrong. It's completely mistaken. The process, you cannot choose to be selected by Navy or the DOJ for this program. They have to choose you. So they go through the files and they review the ones that they think, see if they can find the ones that they think they can settle. That is, they think that maybe somebody's desperate enough that they'll take pennies on the dollar for their case, or they see if they find someone that has a lawyer dumb enough to settle the cases on this basis. So they have submitted, at this point, there have been, out of 232,000 cases, they have found 551 that they thought were eligible for this program. But then from that 551, they narrowed it down to 131 that they would actually try to make settlements with. Of those, they have settled 58 cases. So as long as that program's been run, they've only settled 58 cases. They settled those for $14.4 million, which means that the average settlement was $248,000. Now, giving these cases away at $248,000 is a crime. So that's where it is now. And I tell you that by way of, if you hear about somebody that got a settlement or whatever, that's what it is. Because as far as settlement is concerned, the big lie started with the first ad that was run in this case. On August 10th, the day President Biden signed this bill into law, there was an ad that began running massively all over the country and just over and over and over again that said, the government has set aside billions of dollars for a settlement for clients, for Marines who were exposed to the toxic waters at Camp Lejeune. Okay, that lie started such a mess because there was not a settlement. There's never been a settlement. There's not a settlement now. The only settlement that there is and has ever been is the one I just told you about. It has to be initiated by the Department of Justice or by the Navy JAG. And those EO settlements are the only ones that have been made. So if you hear about somebody getting a settlement or whatever, it had to be through the EO. Now, a lot of people are lying about settlements. Uh, a lot of politicians are lying about settlements. Senator Sullivan, who is so totally opposed to this legislation from Alaska, he came out and told a story about he met a man who had a case that was settled for $35,000. And that when they got through paying all the attorney's fees and the costs and so forth, the man got $3,500. That is an absolute unequivocal lie. So the fact on settlement is this. Here, I'll tell you how you get to settlement in this case. We have a settlement, a resolution committee. The resolution committee will be involved in setting up matrices, a matrix, and they'll set up a matrix on each of the diseases that they think are worthy of settlement. And what they do with that is they'll take something like kidney cancer, for example, and they will talk about all of the elements that go into evaluating a kidney cancer case or kidney disease. Let's do a kidney disease case. So they'll talk about, okay, you have to have the types of surgeries you might be exposed to. They talk about the fact that you be on dialysis, how often dialysis is, how much it costs, that you're in line for a kidney transplant, and all the elements that go into that, or that you may have a kidney disease death, and all the elements that go into that. And they'll pick all those individual elements. And by an element, I mean things like the cost of dialysis, and then the pain and suffering and mental anguish and physical disability that go along with being on dialysis 3 times a week for 3 hours or 3.5 hours, and all the mental anguish involved in that. So all those elements, those individual elements, go into a matrix. They have an individual box, and they will try to put a value on each one of those boxes. Usually they'll use a point system. And they'll put a value on each one of those boxes. So then when they get a case in, they will take a kidney disease case and they'll look at it and they'll say, okay, he was on dialysis, check. Yeah, so that check that box. And he got a kidney transplant, so he went through kidney transplant surgery and so forth. Check those boxes. So they check off the boxes of the elements that each individual plaintiff has that fit into that matrix. So to evaluate your case, eventually, if you have a kidney disease case, to evaluate your case, we'll take your elements and fit them into the matrix, and then that'll tell you how many points you have. That'll give your point analysis for the value of your case. Then to put a dollar value on it, this is where the trials come in. So we're going to try cases of kidney disease. And when the kidney disease cases are tried, at this point, we're talking about maybe trying 20, possibility of trying 20 cases of each of the diseases. So it'll be, if we do that, then that will give us data as to how the judge values the cases. So then they take the data, the damages data from the cases, and they send it over to the resolution team. and the resolution team breaks that down and puts a value, like on the box level, they'll put a value on dialysis, and they'll put a value on kidney transplant. They'll put a value on living with end-stage renal failure, things of that nature. And then they total that up. Now, that's just the very, very, very basic. Now, then you have to take into account the other elements of how long were you on dialysis? How long were you in end-stage renal failure before you managed to get to dialysis? And then how long were you awaiting a kidney transplant? Did you get a kidney transplant? And go do a deeper dive on each individual case to see where how expansive the elements in it within the matrix will be from the facts of your case. So it's a good system. It's been used. It's often used in mass tort cases at the end of the day to try to evaluate your cases. And then my job is to see to it that your damages are fully developed, so that when we submit your facts into the matrix, we know what all those facts are. So in order to do that, we do a deep dive on damages, and I'm gonna get to that. I'll get to that in a while, because that's the last topic I want to talk about, and what your role can be in that deep dive on damages. So that's where we are right now. The resolution, they're waiting on the resolution, and they have not yet agreed on a settlement administrator, because the settlement administrator has a big role in forming the matrix, because the DOJ is going to be on one side saying, no, that shouldn't be worth this much, and the plaintiffs are going to be on this side saying, yeah, it should be worth more. Well, the settlement administrator is the guy in the middle trying to bring those two sides together in evaluating those cases, so we can get to case resolution. So right now, there has not been a settlement administrator appointed, which is fine, because they haven't started trials yet. They don't have that data, but they're forming the matrices right now, and the matrices they'll form will be on the top 10 tier 1 cases, which I'll talk to you about in a minute. So the next thing, so that's it for where we are in Navy JAG right now. The reason I mentioned that in connection with Navy JAG is that the Navy JAG is responsible for the EO. They're responsible for that whole EO program. And then we have a committee of our own now that's responsible for the resolution program. The DOJ has a committee, has members on the resolution committee, and then the claims administrator will come in and will head the resolution committee. So that's the status of settlement at the moment. So if you hear anything about settlement, about big settlements, people sometimes the ads will lie to you about settlements, and they're just simply that, they're lies. So let's talk about what's going on in court. It's been a hectic time, because the statute calls for trial by jury. The statute specifically said that we should have trial by jury in this case. The court ruled that we are not entitled to a jury trial. So then we wanted to take that up to the Court of Appeals. But in order to do that, because of the way the rules are structured, in order to take it to the Court of Appeals, we have to have the permission of the courts who made the ruling in the first place to go to the Court of Appeals to appeal their decision. Well, the courts decided that they would not let us go to the Court of Appeals to appeal their decision. So at the moment, we are clearly on path for judge-only trials. Most lawyers will tell you that they always want jury trials, and as a general proposition, that's right. I am not bothered by the fact that we have judge trials because judges can be influenced by intelligent argument, intelligent presentations, the same as jurors. When they're sitting as a fact finder, they're subject to the same influences of an excellent trial story as jurors are. So I'm not even remotely bothered by the fact that we're not getting jury trials, because it would take 3 times as long to get through cases involving a jury as it would for judge-only cases, because it's a massive amount of work for just for the office, for the court's office, to bring in just thousands and thousands of jurors, and to spend time on board examination and charging the jury and all that sort of thing. All that stuff is out of the way. So it takes a third of the time to try a case to a judge as it does to a jury. With the number of cases we have to try, that's a very, very big deal on how soon we can resolve this whole thing. So I'm perfectly happy. And I'm trying our wounded warrior cases. I also represent wounded warriors. To give you an example, we represent the victims of the attack groups that are funded by Iran. And we have 2,651 of those cases. And we're trying those cases to a judge. If we had to try those cases to a jury, it would take us forever to get them done. They're very complex cases, and it would take a long time. We're trying them to a judge because that's the law in that case, in those type of cases. But in those cases, we are getting massive damage recoveries. And we would not get any more from a jury. These are federal judges sitting as fact finders, just exactly as the courts in North Carolina are. They're federal judges sitting as fact finders. We're representing military veterans whose lives have been horribly damaged or destroyed. And the money comes from the US government. In our case, it comes from Iran, but also there's a fund made up of things that when they foreclose, when they put sanctions and so forth on countries, there's a fund made up from that pays the judgments in this case. And to give you some idea, we had a pretty good week here at the Nation's Law Firm this week. We're a member of a consortium of 6 firms that decided 7 years and 3 months ago today that we were going to prosecute those cases on behalf of those wounded warriors. Now, we had to build it from the ground up. It hadn't been done before like this, with this many cases. And so this week, we got our first judgment. And this doesn't apply to how long it takes for your case, believe me. But we got our first judgment this week, and it was for $939 million just for our Bellweather cases in that trial. So I'm telling you, when they say that, oh, we're not going to get any money we're not going to get fair money out of a federal judge. Well, we do. We did it this week, and we still got 2,500 more cases to go. So trying cases to a judge does not bother me at all. In fact, I just wish we could get on with it. So the next thing is in terms of where is your case right now. I'll tell you that in the court, in the district court right now, there are 1,788 cases on file. That's all. Out of 232,000, there are only 1,788 cases on file. And those cases are cases that we selected, cases that we had at the time. In the beginning of this litigation, we selected the best cases and we only filed our best cases. But then when we got up to 1,700, we were okay, let's stop at that point because we don't want to imagine the total chaos if we had 232,000 cases filed in a federal court or in 4 federal courts. Just that's idiotic. So from these 1,700 cases that are before the court, we are selecting bellwether cases. And the court designates for us what the bellwether cases are. And they look at it in terms of, they tell us, okay, we want 20 of these cases. And so they're set up on tracks. We run with track 1, track 2, and track 3. And we're up to track 3 now. So the court told us in the beginning that they want bellwether cases. And they told us what kind they wanted. They told us at the very beginning, they started with bladder cancer, kidney cancer, and then we had Parkinson's disease and leukemia and non-Hodgkin lymphoma. And so those are the first cases that we had to submit our bellwethers on. Now, how bellwether happens is that attorneys like me, the judge says, we have these 5 cases. This is what we want you to try first. So they send out an order to us. We go through our bladder cancer, kidney cancer, and so forth, all those 5 cases, and we pick out the very best ones we have. And we send those in as a bellwether case because we only want our first trials to be of bellwether, of our best cases, obviously, because it's going to help set the values of these cases for settlement purposes. So we send in our cases. Every other firm that is interested in doing so, that thinks they have a good bellwether case, can send in their cases also. And so then they have a bellwether committee and they go through and they vet these very carefully and they choose the best of the bellwethers. And then we prepare the bellwethers. And right now, where we are exactly is that the judges have told us that they want right now, in order this week, they want to pick the best 25 cases that we have for the first trials. And so that's what's occurring right now. They're selecting the 25 best cases, and those would be the first trials. So we're down to the point of actually selecting actual cases for a trial right now, which means that the beginning of trial is not far away. So now what's been happening. So if you want to know what the status of your case is, I'll tell you what's happening to the cases right now. We have been going through and reviewing. We review your cases. We file your cases first. And then after then, we go back through and we review, and we're preparing your cases for damages analysis. First, we're seeing if your case is going to qualify as a case. I'll tell you, out of the 232,000 cases, I've said this from day one. Out of those 232,000 cases, there are just thousands of them, tens of thousands of them that will not be paid because they do not qualify. There are lawyers out there taking cases. They're taking cases for arthritis. I mean, you got an 80-year-old man with arthritis who drank the water at Camp Lejeune. I mean, seriously, we've all had some degree of arthritis since we were about 55 years old. So there are a lot of absurd cases out there like that because the lawyers didn't do their job in vetting the cases before they took them. Now, we know that um, we know what the best cases are, and we're moving forward. That's what the court is having us move forward with. So, what we can look at, what's happening to your case, is we're going through them and make sure all the qualifications, everything that needs to be done in your individual case is done. And now, uh, what we're doing also is I have been doing focus groups, and I'm going to come back to you on this, but I have been doing focus groups on each type of case in order to determine the value of it. So right now we're in case preparation, and we are in the process of uh, getting ready to parse out our cases to see which ones are most representative. We're picking the cases that are most representative. For example, again, if we look at kidney disease cases, then we have a number of them. So we'll look through and we may find the 10 that are most representative of everybody else. And then what I'm doing is I do focus groups with those people, and to try to establish a mean damages level. And we get a lot of people. We on our focus group we use people from North Carolina who are they're juror qualified. So we get qualified jurors from the area where our courts are, and we bring them in, and we present cases. We present cases to them of our actual clients, and then we get a reading from that of how many of what each case, the spread of values. These cases have a low value of this and a high value of this, depending on, and then what's in the middle is where we come down to assessing the value of your individual case, and I'll tell you how you can help us with that in a moment. So the trials there's a wrinkle in the trials now. We know they're going to be judge trials since they denied our possibility of a jury trial. There's a piece of legislation pending that was just filed with Ed Bell's support, which, if it passes, will open up that we can file cases anywhere in the Fourth Circuit. We're not just confined to that one courthouse and those 4 judges. Now, if that passes, we can try cases in a hurry, because they can assign 20 cases out to another court somewhere, and just they can move through these cases. So when the case is going to be tried, it's going to depend on that legislation. If it comes through, it will speed things up considerably. The next thing is we have to deal with what we actually have right now, though. So what we have is we have 4 judges who are looking at 25 cases coming up in the next month, and then they will tell us when each judge has his own docket. So each judge will tell us, okay, I want this trial. Send me this case on this date. And that's when the trials begin. Now, What we're trying to do to expedite trials is to convince the courts to try 10 cases at a time. Back in the asbestosis days, we used to try 30 cases at a time. We used to submit 30 cases to one jury in one trial, and it worked extremely well. And we're trying to get the courts here, we're trying to break them into that by getting them to take 10 cases at a time. Now, if they'll take 10 cases at a time for trial, they can do that in a week. They can handle 10 cases in a week easily in a non-jury case. And if we had 4 judges doing that, we could try 40 cases in a week. And if we did 40 cases in a week, we could move through this data that they need for the matrix very quickly. So we'll see what they do with that. As far as we know right now, they're only going to try one case at a time. So I hope they adopt our suggestion and move up to the at least 5 cases at a time. That's very simple because it'd all be the same. I mean, it'd be 5 cases of leukemia or 10 cases of leukemia. They'd be trying the same disease, which makes it very easy. Then it's just a matter of taking the individual testimony of each of the 10 plaintiffs to establish their individual value of their case, which is not that difficult. And so we're praying for that. If we get that, we'll move through these cases very rapidly, and we'll start seeing some serious settlement negotiations. I'll deny I ever said this, but we could see serious settlement negotiations taking place by first quarter, second quarter of next year. Now, let me tell you how that's going to work. Because the cases are being handled on a track designated by the courts, and because they rely upon the data from the trials to fill out the matrix, then the cases that the judge calls for first will be the first ones that make it to the matrix. So say bladder cancer, for example. Now, we tried 20 bladder cancer cases. That information goes to the resolution committee, and they're over there filling out that box. Now, the beauty of this litigation, differing from other MDLs, in other MDLs, you have to settle every case before you get paid on any of them. I mean, it's really a mass tort thing where they won't pay anything until they settle everything. That's not the way this is. So let's say you have a bladder cancer case, and we try 20 bladder cancer cases first because that's what the court wants to do. And then the data goes over to the matrix, and they set up the matrix on bladder cancer. By the time they get that matrix on bladder cancer set up, it's time to start negotiating bladder cancers for resolution. So then people like myself, I would say, okay, I'm ready to go. I have X number of bladder cancer cases. Let's get started on resolution. So theoretically, I could go over and settle every one of my bladder cancer cases within the matrix at one time and just do them. I mean, they're individually settled, of course, but I mean, I could settle using the matrix. I could settle every one of my bladder cancer cases before anything else even gets considered for the matrix. So it'd be possible to eliminate all bladder cancer cases and then just move on to the next thing. Now, at the same time, they'll be doing kidney cancer cases. So whichever one gets over there first, and then enough data comes out of the court for the next one, maybe kidney cancer, the next one maybe Parkinson's. But the way this is going to work is they're going to deal with bladder cancer, not in this order, but this is how, unless the court call them in this order, decide to try them in this order. There'll be bladder cancer, kidney cancer, Parkinson's, leukemia, and non-Hodgkin lymphoma will be the first 5 cases that make it into the matrix. And so those will be the first 5 diseases that will be up for settlement, because those are the ones that will have the data first. So if you don't have one of those 5, you're not going to be in the first round of settlements. But whatever you have, and we have nothing to do with this. This is strictly the judges. The judges tell us what cases to bring over, and that's how we present them. So then the next batch of cases, track 2, the defense. Track 1 was basically chosen by the plaintiffs. Those are all tier 1 cases, and we chose those. But in track 2, the defense got their say on what gets chosen. So they chose for track 2, following when we finish this first batch. Track 2 is bladder cancer. Track 2 is breast cancer, prostate cancer, lung disease, liver cancer, lung cancer, and kidney disease. Track 1 is kidney cancer. Track 2 is kidney disease. Right now, the science does not have strong support for breast cancer cases. The same thing is true for prostate cancer cases. And the same thing is true for lung cancer cases. These are tier 2 cases, which means they don't have sufficient science backing them up to get past an expert witness test, Daubert test. But that doesn't mean that you can't take individual cases. Even if a case does not qualify, you could still bring an individual case in for trial. Bring in your own epidemiologist, bring in your own, say, lung cancer expert, and that lung cancer expert could give the necessary expert testimony to qualify that lung cancer case for moving forward and getting a trial. The difference is on the tier 1 cases, the evidence, the scientific evidence produced by the federal government supports the proposition that drinking this toxic water containing this toxic carcinogenic chemical can cause this particular disease. Now, so those tier 1 cases, they don't have to worry about the expert witness's testimony is easy because there's plenty of evidence supporting those tier 1 cases. So, but that doesn't mean that tier 2 cases cannot be won. So the next thing, okay, so then we go through the tier 1 cases, presenting them to the courts as they ask for them. Then we'll continue with that through that track system, and it has been believed, and they're talking about moderating this now, but it's believed that we'll go through 3 tracks. It's believed that we'll try 300 cases, and that will be the total number of bellwethers. And by the time we try 300 cases, that will we'll have enough information to fill up the resolution matrices. But here's the thing, remember this, by the time you get down to trying that last batch of cases, you could be already settling the first batch of cases because it takes so long. Because the let's say cancer, and let's say bladder cancer is the first one that goes over there, then they can be building that bladder cancer matrix, and they can be settling those cases while track 2 is even being hadn't been tried yet. So it's not. This is not going to be a big, massive. They're talking about a global settlement, but if they're going to do it by use of the matrix, which is the current plan, I don't see how a global settlement works in this case. There's too much disparity between the individual cases. I mean, we've studied these cases in depth, and we've talked to our clients thoroughly, and we know the difference. You just can't say, what's a kidney disease worth? Well, I can show you kidney disease cases that are worth nothing. And I can also show you kidney disease cases that are worth millions. So you can't say, well, in a global settlement, what's a kidney case? What's a kidney disease case worth? Because there's such a huge disparity from the low end to the high end. The case worth nothing would be one where the plaintiff gets kidney disease and just at the time he discovers it, he dies immediately, or they discover it on his death. Well, if they discover it on autopsy or something, he had no physical pain, mental anguish, and so forth. He had no damages. So all right. So the next question is, what can you do to help in your case? Because my concern is taking all this and applying it to your case. My concern is evaluating all of your cases. So what I'm doing is the way I just wrote an article that was published this week in Trial Lawyer magazine, and I think the article is posted on our website, on our veterans website, which is justiceforveterans.info. And I think you'll find my article about what we're about to talk about damages. You'll find my article there. It should have been put up yesterday. Magazine just came out 2 days ago. I think we got that article posted yesterday. If it's not up there, it'll be up there soon. So let's talk about damages and how we go about developing damages and identifying damages. So what I do first is I focus the disease. And this is where I can use some help from you. We take, like we did this already in kidney disease, for example. So I brought in 9 of my clients who have kidney disease. And of course, they all volunteered, and they're all anonymous. I mean, they just use their first names. So we don't violate HIPAA, so they're not disclosing medical information to other people, but they're volunteering to do it on this basis, and also nobody knows who they are. They only use their first name. So I bring in 9 or 10 I brought in 9 of my kidney disease patients, and we just start talking, and I tell them, here's what this process is about. You know all there is to know about kidney disease. You're suffering from it, you're experiencing it, you're enduring it, you're tolerating it. I don't know, I've read all the science. I know what the science is on the causation. I know what chemicals cause it. I know all the science. What I don't know is what it's like to live in your body with kidney disease. Those are your damages. So in order to help me understand what damages I need to prove for you, I need the 9 of you to tell me what you're going through, what kind of physical pain you're having, what kind of mental anguish you're having. So it's pain and suffering, mental anguish, physical disability, physical disfigurement, loss of enjoyment of life, that type of thing. So we spent 3 hours talking, and I said that my job is to listen. Your job is to educate me. So I want you to tell me this. So then we'd go through uh, the original diagnosis. Uh, we'd go through the treatments and the side effects of treatments. We'd go through the surgeries and the after effects of surgeries. Uh, and we'd go through the medications and the side effects of each of the medications. Uh, and we just go through the entire body of damages. And then what can you do now that you couldn't do before as a result of this disease? And then the way you do this, and what we do is we create a story for you. And the story consists of, I get you first to tell me on an individual basis, tell me what your life was like before the diagnosis of your disease. And it's because if you're going to be, the jury is going to be trying to put a dollar value, or a judge will be trying to put a dollar value on your life damages today. They need to know compared to what? Where are you today? Well, we can see where you are today, but what do I compare it to? So what they compare it to is your life before. So we go into detail on what your life was like before you got this hard disease. Then we go through the entire life now, the consequences of having the disease, incidents that have occurred to you, falls, any type of additional injuries that have been caused, uh, the incredible distraction and horrors of having to take chemotherapy. The last one of these I did, the client was on double chemotherapy. You do a session in the morning and take a break for lunch and come back and do a session in the afternoon. I mean, that's just incomprehensible to go through that. So we go through all the types of therapies that you've been through and so forth. So we do an analysis of your damages, and we go through, we know what they are. By the time I get through this session with these gentlemen with kidney disease, we're sitting there, we're recording it, we're making a list of their symptoms. So by the time I get through with that session with them, and we review our notes and we review the video, I know all I ever need to know about kidney disease to prove your damages if you have kidney disease. And so then I can take that information and write that into your trial story, because now I know what your trial story is all about. So that's the first thing I'm focusing, is focusing the disease. And I'm focusing all of the tier 1 cases. And I've already done 3. We still got 7 to go. But this helps us. Then we take all that information back, and based upon that, we can evaluate the damages of each of everybody we have. We know how to test them for the damages of kidney disease. So we apply it to every kidney disease client we have. So that's one way. Okay. The other thing I do on focus groups is to bring in clients, and we'll bring in one client, and we'll write your trial story. We may take one of the 10 people that came in and volunteered for the to participate in the discovering the disease. And then we'll take one of them and we'll say, okay, we're going to do a focus group. So then we present that person to a focus group. And we have you, we'll develop your trial story. And then we'll have you, there are a lot of ways to do this, but generally we'll have you put your case on in 40, 30, 45 minutes. We'll have you tell your story to the focus group. And then the focus group listens to it. And then we send you out of the room, and then the focus group discusses your case. What questions do they have about it? And they're told that they are going to be called upon to assess damages, pain and suffering, mental anguish, physical disability, physical disfigurement, loss of enjoyment of life. And so they'll talk about what they've heard from you in terms of your damages. And they'll also talk about how good the story was. Did they really understand the story you were trying to tell? And then they'll talk about how good you are as a storyteller. Is there something you need to improve to improve yourself as a storyteller? And then they will bring you back in, and they get to ask you questions about the questions that they have from the first time they saw you, and from the instructions we've given them. And then after we do that, you get to make a statement to them if you want to. And then after we do that, we have them serve as a jury. We leave the room, we leave them alone, we give them a court's charge, and we listen to how they talk about your case. And usually they'll have an hour. So they'll deliberate on your case, and we learn all the weaknesses, we learn the strengths, we learn what they believe, what they don't believe, we learn what they, mostly importantly, we learn what they didn't understand, so that we can helps us make it clearer in creating and telling your story. So when they learn, and then we ask them to deliberate on damages individually, talk about pain and suffering, and then we'll listen to how they talk about pain and suffering. What about your story resonated with them? What did they miss? What went over their head, or they just didn't get it? And then we'll listen for the use of metaphors and analogies and other rhetorical devices. And we listen to the language of the case. Every case has its own language, and that is key words and phrases that pertain to that particular case. And we'll learn how they deal. We'll learn their language of how they talk about your damages. And it's just so incredibly educational, because it's watching the jury deliberate. And then we ask them to put a dollar amount on, and we ask them first to write down their own individual damages award, so that they're doing it without being influenced by other people. And then we ask them to deliberate on your damages. And they deliberate, and I mean, it's a heck of a process to watch. And then we tell them that they have to come to a final resolution with a unanimous verdict. So then we watch them go from what separates them, bring in how do they get into one number. And that's where we learn a lot, because that's when they have to argue. So if one person says X damages and the other one says Y damages, then they have to debate it among themselves. We want to see what arguments they use themselves to bring the other side to their position, because those are the arguments that they probably, they didn't learn them from us, because we don't argue the case. The lawyers don't tell them how much, there's no argument at all. This is all just their own baseline deliberations. And then they give us a value on the case. But more importantly, the value doesn't really matter that much to me. What matters is, what damages did they believe? what did they disregard because I had failed to make it clear to them. And so I learned how to adjust damages presentations across the board for your particular case. So said I was going to have a request for you. I'm going to be doing additional. Um, I'm going to be doing additional focus groups, and I may be calling upon you. I will be calling upon some of you if you'd like to volunteer when we are testing the disease, and then we'll see if we after that we'll see we'll be doing some individual cases also to establish a mean, and that helps us that'll help us put our value on your individual case and create your own trial story. And just so you'll know, if you wonder what we're doing all this time on discovery, so far the government has produced 12 million pages of documents, and we are reviewing them. That's among the other things we do is we have to review those 12 million pages of documents in our spare time. So there's a lot going on. There have been on the track one depositions, for example, there are 100 depositions on track one because there are 100 plaintiffs on track one. And so in the track one, 85 depositions have been taken all over the country. 85 out of 100 depositions have been taken. So also depositions of fact witnesses are scheduled now. They're scheduling it now. They haven't taken very many yet because they haven't quite finished the depositions of the plaintiffs. So at any rate, that's where we are right now. And so I'm going to open this up for questions. So let me see. Let me take a quick look what we have here on questions. Okay. Mr. Albert, the answer to your question, he's asking if you're on Medicare and have been all your life because of illnesses you have now, how would that work in the set-off? First of all, when we created this statute, we tried our best to leave out the subrogation interests that are held by Medicare, Medicaid, private insurers, and so forth. We tried to not give them a subrogation interest, but we couldn't do that because it made the price of the legislation too high, because the way we passed it with this subrogation, they were able to put into the financial assessment of the cost of the bill an assumption that the government would recover millions and millions and millions of dollars through subrogation. Well, that's fine because they're not going to. So that's the only reason it's in there. So what happens is if one of these healthcare providers wants to recover on what's called their subrogation interest, let's say you go to the hospital and they have a VA hospital and you run up over the years, you run up $100,000 in bills. The only thing they have a claim on is, let's say that 5 million of that was bills as a result of your injury from the drinking water at Camp Lejeune. So first of all, that's all they have a possibility of recovering. The other 95 million, if it didn't come from the injury from the drinking water at Camp Lejeune, doesn't matter. So then on the 5 million that did, then let's say they have the same burden we do if the VA is going to recover that $5 million, they have to come in and prove that that $5 million worth of work they did came as a result of your exposure to the toxic water at Camp Lejeune. And that's a very difficult burden. That's the burden we have. So what happens in this, and this happens across the board, not just Camp Lejeune, this happens in automobile license and everything all over the country. And dealing with Medicare and Medicaid, we customarily negotiate down to about 10%. If we pay them at all, we negotiate it down to about 10%. So if you actually had $5 million of medical bills that they had a real claim on, first of all, we point out that the defendant in this case is the federal government. They are the federal government. So we're not going to be paying big money back to the people who caused this thing. And of course, that was our argument for not allowing it in the first place. So, but we would negotiate something like that down to pennies on the dollar. I mean, literally, like $100,000 or something like that. It would just be nickel and dime compared to what it's worth. Most liens we negotiate down to 10% or less. So those are not going to be. We're also trying to make a deal that will cut out this whole the part that the government controls. We just cut that out on the U.S. government. We're trying to make a deal when we get to the end of this that they're just going to cut out subrogation and not fool with it because they know it's not going to be enough to fight for in their case. So now we can't cut out Medicaid as a state, so that's different. And then private insurers, we also have to deal with them too. Okay, let me take the next question. The next question, okay. The bottom line is pretty much, the question is, what's the bottom line? The bottom line is you're looking at, depending on what your disease is going to establish when you get paid if we continue to use the matrix system. And if we continue to use the matrix system, as I said, settlements will start. They'll probably get to resolution early part of next year on the earlier cases. If it's a global resolution, I can't imagine making a global resolution on this many cases. So if it's a global resolution, there's no telling how long this would take us to deal with that many cases. So I have no answer for that. All I can tell you is that if we proceed along the lines that we've always planned and that we're proceeding on now, I think that we will be into the possibility of resolving the first round in the first quarter of next year. Next question. No, there's not we don't have a settlement time frame for non-Hodgkin. No, we don't have a settlement. We don't have a settlement time frame for anything other than what I just told you. Now, with respect to the non-Hodgkin lymphoma, it is in the first tier of cases that are being tried. So non-Hodgkin lymphoma will be one of the earlier settlements. But as far as the time frame, we're looking at next year. My mom had this cancer twice, destroyed brain as well. Don't see a question there. Let me see, hold on, let me scroll down. Okay. Will those with liver cancer receive any compensation? Liver cancer is in the track 2 cases. As we talked about, we're on the track 1 cases now. Liver cancer is in track 2. So we got to go through all the track 1 cases with trials, and then when they finish those 5 those five, track one will be 100 cases. Then they get to track two, which is the second 100 cases, and liver cancer will be one of those. So that's the best. That's about all I can tell you about in terms of time. Is it's second in line, but behind the first five cases. Um, the how we the the question is how can we speed up the process with the DOJ? The answer is we're doing everything humanly possible to speed up the practice. But let me say this: the DOJ is not slow playing these cases. They're not because not because they're really nice guys, but because the judges won't let them. The judges, you can imagine the judges' situation. Every one of these judges have a full docket before this case was ever brought. And then on top of a full docket, they get 232,000 cases assigned to their courts. So you can imagine what chaos it's creating in their courts. So they are warning, they've told us from day one. Judge Dever had a meeting with us April 5th of last year, and he said, you want trials in these cases, you're going to get trials in these cases. We're not going to sit on these cases, we're going to move them forward. So so he started moving it forward. The thing that slowed it was when they had to, when they filed a motion and they did away with the jury trial. But while that was going on, we were still preparing the cases. And so that the cases, there's not been a time when we haven't been pushing forward on these cases, and the DOJ is going along with that. There's nothing to do. There's nothing to do. There's nothing to do to get it going that we're not already doing. To what degree do you see this process being affected by politics? The judge affiliations, political affiliations, I don't see this. I don't see this I don't see politics having any influence on this. These are veterans, and as a general proposition, the veterans get great respect from the courts. We had great respect. That's how we were able, we pushed this thing through Congress on the basis that how can you not vote in favor of giving a cause of action to veterans who were horribly damaged as a result of intentional conduct of the United States government. So it took us years to get the Republicans to sign on, but we had 50 Democrats the whole time. And then we finally got 10 Republicans to sign on in 22. And then once we had enough to pass it, then we got 36 Republicans signed up. But I don't see politics, to answer your question, I don't see politics plays any part in this case. These are four excellent judges, honorable judges. And this is just, this is not the situation in West Palm Beach. What about wrongful deaths is the next question. Wrongful deaths are being prosecuted, and you have claims under the Wrongful Death Act. You have a claim for the beneficiaries of the decedent. So you have to go through that, and we're handling that for you. The survival action, there's two things, there's wrongful death and survival. The survival action is the action that the decedent would have had he lived. And what that means is if he gets the disease And from the time he gets the disease, he goes through 20 years of suffering from the disease, and then he dies. Okay. His claim, the survival action, are the physical pain, mental anguish, physical disability, physical disfigurement, loss of enjoyment of life, and his economic damages during those 20 years. If he got the disease and just died immediately, or they discovered the disease on an autopsy, he's got no claim for his survival. The claim of the individual plaintiffs under the Wrongful Death Act depends upon their relationship to him, the relationship first, and then secondly, the personal relationship. How much did they rely on him for support? Did they, that type of thing? A lot of elements go into that, but they have individual claims, and that's what we're handling those. So that's wrongful death. We've had a big holdup at the Navy JAG because they didn't know how to handle wrongful death cases. And I mean, it's taken us, a year and a half to get that figured out, but we've got it figured out now. The next question, lung cancer, is on the list. It's on the tier two list. That makes it this. All right, the next question. Yes, the question is, I'm representing both of my parents who have already passed. Will their case still be considered now that they have passed? I also lived at Camp Lejeune as a child with no symptoms. Okay, so yes, the wrongful death actions will survive. We have to look at them. We have to look at the individual facts on them. Like I said, one case, if they discover and on their death, no damages, but if they lived with the disease for a long time and died, then they do have the survival action. So yes, both of them have the possibility of recovery. It's individually fact-based. Will we need to pay back medical bills for the track here? That's what I just talked about. With everyone, we're taking a very, very, very hard line. But as we always do, if we do pay them, it will be a nominal settlement. I mean, we're not letting them dig into the recoveries of the veterans. North Carolina has an unusual death law. That's true. Well, we've worked out the problems with the North Carolina. I had mentioned that before, that there was a problem with the wrongful death case, which is why one of the reasons we've had to go on for so long is that the statute does not contain a wrongful death and survival action, and neither does the federal common law. So we're required, we have to go to the wrongful death law in North Carolina. Well, the problem with the wrongful death statute in North Carolina is North Carolina is a contributory negligence state. It's one of the few, I think there may be 3 left in the country, which means if there's 1% negligence on the part of the plaintiff, you can't recover anything. So in this case, we're getting around that. We have to, and I've always said, we can't adopt the wrongful death law because of North Carolina, because the DOJ will come in and set up contributory negligence. Well, our position is this is not a negligence case. So we have to adopt the law of the statute, just the part we need about definitions and so forth, without adopting the statute. And so that's what we're doing at the moment. The next question is about esophageal cancer. Esophageal cancer is a tier 2 case. There's some science on esophageal cancer. which means that you may be able to bring an individual case. It is not a tier 1 case and will not be one of the bellwethers. The next question is how much money is actually put aside to settle these cases? The answer is that first ad was a big lie. There is no money put aside to settle these cases. The limit of the liability on this case is the federal treasury. You're paid directly from the Department of Treasury. So we get a judgment on a case, we take it down to the Justice Department, to the Treasury Department, we file it with them along with a final judgment, and we get paid in 30 days. So we know that the federal treasury is bankrupt, but as long as they have printers, we're good. How long can this process take? We've already been waiting. You've been waiting so long. My wounded warriors that I talked about earlier, they've been waiting 7.7 years and 3 months. This is moving. You could not, if you had just filed a single case, a single personal injury case in federal court, when we filed your case, when we filed the first cases in here, you would not have a trial yet. We are moving hundreds of cases through to trial at the same time. And this is so fast, it's unbelievable. The case didn't reach court until June of 23. So from June of 23 until now, we're looking at a year. Nobody gets to trial in federal court in a year. Most personal injury cases filed on their own, depending on what jurisdiction you're in, will take 2 to 3 years to get a trial. So this is nothing. We're going to have these first trials that are done will be done in record-breaking time. Absolutely. The question should we be gathering medical records? That depends completely. Yes, you should be gathering medical records. If you can pull together all your medical records, then we'll call on you for them as we need them, because we're trying to, the reason I say if we need them, we're trying to get the Department of Justice to agree to accept, instead of receiving hundreds of millions of pages of medical records, we are trying to get the Justice Department to agree to diagnostic codes, so that if we could simply submit your first page of your medical records, your surgical report if there was one, but your diagnostic report, want the page, if we could just submit the page that has the diagnostic report along with surgeries, initiating page, surgical pages, diagnostic pages, and the final discharge page. We could just get by with 4 or 5 pages instead of literally millions of pages of medical records. We're working on that, but in the process, thank you for the question, because yes, you should be gathering all the medical records, and you're entitled to your medical records. You just have to go to the hospital or the doctor and fill out a request for the medical records. Those are your records, and you're entitled to receive them. And so you fill out their form. You fill out their form for medical records, and don't let them tell you that you have to pay for them, because you don't. Those are your records. Where's this group on this meeting as far as in front of the line? On this, where is this group on this meeting as far as our group? This group, I was one of the people that started filing cases, filing claims on the first day. So a lot of the question is, where is this group? In other words, my clients, as far as being in front of the line or back of the line. We're definitely in front of the line, because we were literally the first one to file a claim. Our group was the first ones to file a claim. and then we've been filing claims ever since. Throat cancer patients, there is not enough science on throat cancer to qualify as a tier 1 case. However, if you got an individual diagnosis from a doctor and an epidemiologist, throat cancer is the type of case that may be able to qualify as a one-off case. It will not qualify as a tier case. How you handle those who are deceased? They're being handled with the filing of the wrongful death case, and we have a team. We have a state lawyer, probate lawyer, assigned to working on this with us, and we're treating the death cases now just like the other cases. We're just filing them on a regular steady basis. When do we anticipate track 2 cases being tried? I would say that the track 2 cases will come after they finish the track 1 cases, which is 100 trials. So that depends, as I said earlier, can we get the judges to try 10 cases at a time? I don't know. If they only try 1 case at a time, then it takes a while to try 100 cases. So when they finish the tier 1, track 1, they'll start trying track 2. So it's all up to the courts and how they handle this. I have kidney cancer now. Where are the others are the same thing in the lineup as far as going to court? The kidney cancer is in the lineup because the kidney cancer is in track 1. So we're already handling. And see, the way this works is those Bellweather cases. There are Bellweather cases moving forward right now in track 1 on kidney cancer, and there'll be probably 20 of them tried. And so those 20 cases will represent your case. Those cases, that's why they're called Bellweather. They represent every other case in the docket. So you and all the other people with kidney cancer, you'll be represented by the Bellweather kidney cancer cases, and those trials are starting in tier 1. So that would not be that'll be one of the first up. How do we know your case has Mr. Lindo, your case has not been selected as a Bellweather. If you had been selected as a Bellweather, or if you're selected as a Bellweather, we're just now selecting type 2 Bellwethers, track 2. So if you are selected as a Bellweather, you'll be notified for us. You'll be notified from us, and we'll move you forward through the Bellweather process. Esophageal cancer is not a tier 1, it's a tier 2. And again, that's the case where we're trying to develop additional science on it. The next question is, in the event of death, will any forthcoming award be awarded to the estate? Yes. In the event of death, everybody always wants to know that. That's a good question. Thank you for it. In the event of death, then your heirs will have a wrongful death action as a result of your death, and then the administrator of your estate, I'm glad you mentioned this, the administrator of your estate will go forward with your claim, which is a survival action, which is where you get paid for all the years that you suffered from your disease before your death. Now, be very sure, everybody out there, be very sure that you have a will, and that in your will, you name an executor, and you name an executor who will be capable of carrying your case forward in the event of your death. Because I'm telling you, nothing slows a death case down like dying intestate, not having a will. Because then you have to go to court in the county, in the state where you die, and then you have to open the whole administration, and you have to get an administrator appointed or executive appointed. Save all that. Be sure, absolutely sure, that you have a will that appoints an executor or an administrator to prosecute your claim in the event of your death. You save so, you can slow your case down so much, it's unbelievable. If you don't have it, plus you have a lot of additional costs to go open an estate in another state for to open a state like in Florida, for example, it costs you $5,000 just to go through this process. You can avoid all that if you'll just do have a will. So be sure you do that. Metastatic colon cancer is not in tier 1, and it's unresolved as to what the total science is that's supporting it at this time. The question is, when will I be asked to give my deposition? You won't. You will not be asked to give your deposition unless you are chosen as a bellwether case. My father passed and had lots of different cancers. What case would this be under? Well, it would depend. If he had more than one cancer, I mean, we'll handle that. We'll choose the ones that are tier 1. So if he has tier 1 cancer, then that's the one that we go forward with. So, and we also have some that are we have people that have 2 or 3 tier 1 cases. Next question, they say there's a priority. Yeah, well, yes, the priority of the case. What's the priority of the cases submitted? Priority of the cases submitted are the track 1 cases that I went over with you. Track 1: bladder cancer, kidney cancer, Parkinson's, leukemia, and non-Hodgkin lymphoma. Those are the priority cases that are being pushed forward right now. If you don't, it sounds the next question is from about the cancer of the lining of the nerve. We'll look at that, but there's nothing there that qualifies as a claim in this case. But we'll be checking that, the records and so forth, and looking for that. Next question: if a service member died from complication of kidney disease, does it mean an autopsy report must have stated? No, it doesn't. The fact that first of all, the fact that he had kidney disease gives you an estate cause of action, so you have a survival claim anyway. What you would, if you don't have sufficient proof or other proof of kidney disease, then kidney disease being the cause of death, you still have a survival claim for him, where his claim for the damages he had while alive will proceed. And again, that's where you would be appointed as the executrix of the estate and move forward on that basis. Esophageal cancer is not being classified as tier 1. It's a tier 2 now, and they're waiting for additional, looking for additional science on that. Kidney cancer is a tier 1, and there are 20 bellwethers already selected. Should the death certificate include an autopsy report? Yes. If you have you need to get the death certificate in a death case anyway. Plus, if you have an autopsy report, we absolutely have to have that. Does it have to include an autopsy report stating the cause is kidney disease in order to have a cause of action? No. Yeah, that's the same question I just answered. You may not have a wrongful death case, but if you got proof of kidney disease, but not proof that it was the cause of death, you still have an excellent claim for kidney disease. And there are huge damages in kidney disease. And again, if you're the executrix under the will, then you would proceed with that. And of course, we'll do all that for you. Next, what if any of us who lived at Camp Lejeune developing these diseases? There is the development after August 10th of 22. The answer is no. If you have the cutoff date for the development of disease is August 10th, 2022. Now, there is the bill that's pending has a provision that may expand the first diagnosis date past August 10th, but that hadn't passed. I already turned in all my medical records to my attorney in Phoenix. So I still need, now if your attorney in Phoenix, if you turn your records into him, he must have referred your case to me. So you just need to tell him to send me your medical records. Because I'm where they end up eventually. Boy, I agree with you. Question is there nothing for veterans with pancreatic cancer? The answer is right now, you are not in the tier 1 cases. I personally think that pancreatic cancer should be in tier 1. And we're trying to get additional science to support pancreatic cancer as a tier 1 case. So we haven't given up on pancreatic cancer, so don't you either. Because I have several pancreatic cancers, and we're looking for additional science to support it. My husband passed 26 years ago. Yeah, that's the tough part about medical records. Can I still get medical records after 26 years? It depends. The VA is supposed to keep the records. Most medical providers, just regular medical providers, have a disposal standard of 10 years. They'll keep medical records for 10 years. If you don't, we'll find another way to prove it. That's not fatal to your case. The next one, my doctors tell me I do not have much time to live. If the resolution after my death will my funds go in. Yeah, it's the same question I just answered. If you die, your estate proceeds with your claim. Is lung cancer a track 2 or an individual case? Lung cancer is in the track 2 cases. Now, at the time, I'll tell you that lung cancer is not a tier 1 case, which means that there is not sufficient evidence at this time that it automatically has support from the science that it's a tier 1 case. That's what tier 1 cases are. Lung cancer is a tier 2 case, and the problem with it is that there are so very many causes of it that they can't. So many different causes that it's hard to pin it down to any one of these carcinogenics. The question on getting the medical records, my dad's deceased. Okay, if your father's deceased, you go to the administrator of the estate, whoever's in charge of his estate, and they order and just get a list of your medical providers, and the administrator of the estate will order the medical records. If you don't have an administrator, if they didn't open the estate, then you can go to the healthcare providers and give them identification as to who you are, and tell them that you're requesting these records on behalf of your father's estate. Then if they don't give them to you, they should give them to you. If they don't give them to you, call us and we'll get them. Okay, yeah, if the claimant's alive and then they die, the state, it goes to a wrongful death claim. I just answered pancreatic cancer. Okay, this one's about a miscarriage. Um, if if the miscarriage occurred at Camp Lejeune, um, and then you said there's another miscarriage. If the miscarriage occurred at Camp Lejeune, there is a possibility of a case for that. It's not a tier one case, but there is a possibility of a case. And you said she had another miscarriage. Well, if she's still at Camp Lejeune and had another miscarriage at Camp Lejeune, then there's a potential claim for that also. I think I am. Oh, I don't know if I'm out of questions. This is not moving anymore. All right, here we go. What if you have a beneficiary? Well, the just being a beneficiary doesn't give you a claim. Your claim is based on the statute and as a family member. So if there's a death, then you we'll work with you on determining if you qualify as a statutory beneficiary for a wrongful death case. Okay, in part of my case, I had an explanation. No, there's the shriveled kidney that was detected during treatment of prostate cancer could be potentially based on kidney disease, but you'd have to scour the medical records to see if you can come up with kidney disease diagnosis on that. If you can, then there's a potential case. Multiple myeloma has not been picked up yet on the tracks. It will be, but it's not in track 1 or track 2 at this point. I seem to be at the bottom of the list. Brittany, check and see. Check the chat. It looks to me like I'm at the bottom of the list. It won't go down any. What do we have? Okay, I think we're there. So thank you for tuning in, and we will be in contact with you further. And I'm going to try, and remember to check our webpage, because we post things on the webpage all the time, and that's where you get your update. And it's Justice for Veterans at info.com. No, I'm sorry, justiceforveterans.info. It's not a .com. Justiceforveterans.info, and you'll find that we post there regularly. So I hope you've gotten information that's useful to you today, and we'll do this again in about 30 days. And believe me, there is a lot that's going to happen over the next 30 days. So everyone have a great weekend. And again, like always, thank you for your service.